And welcome back, folks. Out in California, the Kellen Winslow, the second trial, is moving along rapidly. And we've been listening to some of the testimony of the alleged victims. Jane Doe number 5, the older woman who alleges that Winslow did some inappropriate things in the Crunch gym. She was cross-examined pretty interestingly. Let's listen to that. Here's Jane Doe number 5 being cross-examined by Mark Carlos. Let me ask our resident criminal defense attorney, Tara Walsh, who is with us. How's he doing? What's he trying to get at? How's he poking holes in her story?
No, I think he's doing a great job in these questions. He seems to be suggesting an alternative narrative, that his client was in the jacuzzi. The only reason he moved over, which may have been closer to the witness, was because there happened to also be a jet there. And he made the comment, "It feels good," because his back was against the jet in the jacuzzi. So it offers a very reasonable explanation, an alternative explanation of the events as compared to what she's suggesting.
Yeah, and Gabriel, I mean, that sounds reasonable to me. You know, you're in a jacuzzi, you're up against a jet. It should feel good. What's the big deal here? She's just misperceiving things. She's an older woman, right?
Yeah, it could be. I mean, that's good questioning. I think, I'm not sure if I thought she said there might have been another person in there too. Or maybe I misheard that. But I mean, like you said, you need to, as a defense attorney, you need to show reasonable doubt. And he's doing a good job of making the jury might believe that maybe she wasn't masturbating. Hey, when I go into a spa, you feel good. You sit there by the jets and it's awesome. So looking at the situation and sitting next to a jet and feeling pleasured by the jet, it's very reasonable that the jury may believe, hey, maybe he wasn't masturbating. Maybe he was just enjoying the jacuzzi there. So that's a good point.
So Judge Brandon Birmingham is with me here as well, joining us from Dallas. So there had to be some motions in limine regarding the fact that at the time of these alleged crimes, the defendant was out on bail and had an ankle monitor. And you hear her testimony at times talking about having a towel, small towel around his waist, but a towel around his ankle. If I'm in the jury, what the heck's the guy got a towel around his ankle for? How does the court handle what would be an obvious, question that's dangling there?
Well, you can instruct the jury, but at some point, jurors need to be told what the truth is about certain situations. And it strikes me that maybe this is one of those situations where the defense may want to bring that out. I mean, it's in the minds of the jurors, they're going to know the timeline. And it strikes me that there's two things that the defense can say. Number one, why would he do that with another man in the sauna? And number two, why would he do that on bond for this? Wouldn't somebody be on their best behavior? And might those be two explanations for why his conduct is not what she's saying that it is? So I'm not sure that we might see that from the defense in this case, but it's possible.
Yeah, and we heard some talk earlier today in one of the other programs on the network. One of the guests suggested, well, hey, this was the one event that was out of character with the others, which were more aggressive and more sexual in nature, and hey, he was out on bond. And I'm thinking that's probably why they weren't more aggressive or more sexual in nature and more contact oriented, because he knew that his whereabouts could be tracked, and in fact they have been tracked to that Crunch gym, and there's been a stipulation to that effect that the parties agree he was there at that time based on, quote, GPS info. They don't tell the jury it was the ankle monitor, but it seems to me that maybe the ankle monitor forced him out of his normal routine and less aggressiveness. Tara, what do you think?
Yeah, I mean, look, I think it's a good move by the defense to stipulate to that fact. Otherwise, I think they run the risk of appearing unreasonable to the jury. There's no need to bring someone in from the state to testify as to the calibration of the bracelet and all of that other nonsense when it's clear that he was there. So I certainly think that makes the defense look reasonable, especially when they're providing this alternative reasonable explanation for his behavior.
Yeah, and it seems, and we've confirmed that there was a pretrial motion that did limit the discussion about the ankle monitor. That makes perfect sense, because if you learn he's out on bond and he's still doing this, it's certainly going to prejudice the jury against the defendant. So it just seems to me that it leaves such a weird question hanging when the testimony is out there. There's a towel around his ankle. Okay. Anyway, that answer is not going to be coming to this jury, not directly anyway, not before they come to a decision in this case. And if you haven't heard yet, basically both sides have rested, and there will be closings coming up next week. So we have going to take a break here. You want to listen to some more testimony? Okay, let's take a break. Examination there of Jane Doe number 1, and by most accounts, she was not the best witness for the prosecution. Right or wrong, Tara Walsh, is it best to get her out there first and then let everybody else support the overall actions and allegations against the defendant?
You know, I will say that in my experience, it's typical for the state to present their best witness first. You know, clearly that didn't happen in this case, but perhaps there was the strategy that they were going to present her first because she was the weakest. And in a case like this, where you do have so many different victims and so many different allegations, perhaps they thought it was best to get her out of the way first and then just move on.
And you know, Gabriel, there were some issues about the blood and the source of the blood, and then the finding of some of the fluids from the defendant on the pants that were worn at the time by Jane Doe number 1. But we know she had some issues with identifying him. You know, in the preliminary, they identified his attorney. She was confused about the vehicle. Well, does it matter when your defense is consent?
Yeah, I mean, here's the thing that's tricky about this case. I mean, you have a transient woman, and typically people that are transient, they're gonna be some sort of mental illness or something going on with them, drug abuse or mental illness. So I kind of knew that was going to be a problem for the prosecution when they had a few witnesses that were transient. And I think it is. I mean, she's changing her story. She can't ID him correctly. There was a change in testimony from the preliminary hearing at the trial. And, I was a little baffled on why they would present her first. But I think that because they have so many witnesses so many Jane Does that are testifying to this abnormal behavior by the defendant, I don't think that's probably why. They probably wanted to get her out of the way because they knew they had stronger witnesses in the end. But yeah, it's definitely someone it's not a witness I thought would help my case, but I think because they won that severance motion, I felt like this case was done. They got all these witnesses to testify about alleged sexual abuse by the defendant, and that's what's bolstering their case. So they might be thinking, okay, maybe she's got credibility problems, but it's another witness in line of the other 4 people we have. So that's probably why I'm thinking they put her on first.
Yeah, and there's a lot of time for them to kind of forget. The jury can kind of soften whatever impact that testimony had. Judge Brendan Birmingham, what about the consent, argument though? Does this woman come off as somebody that is going to put up with the behavior she suggested? And it sounds like she had a lot of opportunity to get the heck out of there.
That's certainly the picture that the defense is painting and has done so throughout the entire trial, is that the actions are inconsistent with non-consensual activities. And that comes down to, did she have a chance to escape? Did she escape? Did she run away? Did she tell right away? Is there a motive for her to say the things that she's saying? And those are all things that you're going to hear in the closing arguments. I guess they're going to be on Monday, where the defense is going to try to convince this jury that, you've got to take each case one at a time. They must stand on their own and evaluate individually whether or not they believe beyond a reasonable doubt that these were non-consensual relationships.
Yeah, and I'll correct what I said earlier. Closings will not be on Monday in that case. They do have some more defense witnesses lined up, and they also have the issue about the older daughter of Jane Doe number 1 and the GoFundMe page, and what did she say in that page, and how is that affecting this trial as it moves forward. So Monday's going to be full of all kinds of activity there in the Kellen Winslow, the second case. Let me ask you quickly one more question here before we move on for the afternoon. Tara, what do you expect from this point forward from the defense witnesses? What's the goal?
Well, I mean, the goal of the defense is always to poke holes in the state's case and to show as much reasonable doubt as you possibly can. In a case like this, where the state's case is largely based on testimony from the victims, and in a case where there is not much physical evidence, a lot of the defense work has already been done in cross-examination. So I'll be interested to see what defense they put forward.
Yeah, and obviously we know there are going to be folks that are poking holes, as you say, in all of these different allegations, but they cover so much time and space and activity. Judge, let me ask you, from an administrative standpoint, you're a judge on this case, and you've got a lot of balls to keep in the air yourself there. And I will give a shout out to Blaine Bowden. Bowden? Did I have that right, Bowman? Yeah, he's the judge in the case that everybody seems to love, as I'm sure they love you, Judge. So
Right.
What is the secret to handling all of these cases, interplaying like this?
I think you've got to anticipate what these issues are going to be. I always try to work with the lawyers behind the scenes. I try to tell them we need to resolve as much of this as we can without wasting jurors' times. So that requires a lot of anticipation, a lot of research individually by the judge before stuff happens. And then you got to run a tight ship with your bailiffs and rely on them for security's sake. Try to take care of as much stuff pre-trial as you can, and then you just go forward. And he's done excellent. It's great to watch him work. I've actually learned a lot from him.
That is high praise. And Gabriel was there. Of course, he didn't tell me that, but Gabriel was there. Quickly, Gabriel, last word. What do you expect to see next week as this thing ramps up much more quickly than expected?
I thought a lot of the work was already done with the cross-examination. Each one of these witnesses, I thought there was some credibility issues with a good amount of them, especially Jane Doe number 1 and I think it's Jane Doe number 4. I think a lot of the work's been done already. I'm not really sure how much more the witnesses are going to put on next week or what they're going to do, but
we'll find out. I mean, I understand they do have a few folks lined up. So Gabriel Sepulveda Sanchez, let me thank you first of all very much. Trial attorney out in Los Angeles, Tara Walsh with me, criminal defense attorney as well, and of course Judge Brandon Birmingham from Dallas. All you guys are hanging around for Aaron Keller and the Daily Debrief, so stay right where you are. I'm going to get out of here. Yeah, leave you alone. Have a great weekend. I'll see you next Monday right here on the Law and Crime Network. Bye-bye.